Hi, hello everyone. Welcome to our channel. Okay, so we are now again to start a new chapter. This time, we are done with obligations. Yay! And so, we have to start with contracts. This is actually a lot easier than sa obligations. But before we proceed, gusto ko lang batiin yung mga BSA students from Eastern Visayas State University. Hello! If nanonood kayo, pa-like and comment naman. And of course, isama na rin natin yung mga BSBA students ng Northern Bukidnon State College. Hi sa inyo dyan! Well, sana makatulong tong video na to para mas maintindihan nyo ang topic natin today. So, anyway, for today's lecture, we will be discussing the general provisions ng contracts. That is Article 1305 to 1317. More particularly, we will be discussing yung definition ng contracts mismo. Try din natin i-distinguish yung contracts from the other terms such as obligations and agreements in general. And we will also be discussing the stages of contracts. Sama rin natin yung classification of contracts or yung kinds of contracts. And lastly, pero dito talaga magfo-focus yung discussions natin sa characteristics ng mga contracts or yung mga basic principles. Okay? So, simulan na natin. Article 1305. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So obviously, Article 1305 provides for a legal definition ng contract. Ang sabi, meeting of minds. Okay, sa Tagalog, in literal translation, ang pagtatagpo ng dalawang isipan. Diba? Or between two persons. So, pwede rin namang two parties. Actually, it refers to two parties. So, meaning, pwedeng mas marami pa. Wala naman kasing meeting of minds ng isang tao lang, right? So, kailan ba nagkakaroon ng meeting of minds? Kailan mo masasabing nagtagpo na ang isipan ng dalawang parties? It take place when an offer by one party is accepted by the other, di ba? Nagkasundo, nagkaroon ng agreement. Now, question. Para lang ma-emphasize, okay? Para hindi kayo malito kasi para sa akin mahalagang malaman nyo siya as early as now. Kailangan ba, itong question, kailangan ba na ang kontrata or yung contract ay in writing? Kailangan ba may papel kung saan nandoon ang agreements or ang usapan ng parties? The answer is no. Bakit? Look at the definition ng contracts. It is the meeting of minds. So, meaning, it is not necessary na nakasulat siya. Except lang doon sa mga contracts, meron din naman exception. May mga contracts na ni-require ng batas na dapat nakasulat. But generally, hindi kailangan na nakasulat siya para magkaroon ng kontrata. Kasi nga, by definition, it is the meeting of minds between two persons. Sa sandaling yung offer ng isang party ay tinanggap ng isang party, okay, ng kabilang party without any qualifications, okay? So meaning nagkaroon na ng meeting of minds between the parties, at that time meron ng kontrata. Right? Malinaw ba? Okay? Dapat malinaw yon. Save only for those instances na ni-require talaga ng batas na dapat for a contract to be valid, kailangan naka-in writing siya. Like, example is yung sa donation. Okay? Now, let's discuss also or let's distinguish contract from obligation. Yung contract is actually one of the sources of obligations lang. Yung obligation is mas broad, okay? It is the legal tie or the relation that exists after a contract has been entered into. Now, if natatandaan nyo dun sa discussion natin sa sources of obligation, isa doon is contract. So, yun nga. Meaning, there can be no contract if there is no obligation. Kasi pag nag-enter ka into a contract, malamang may obligation yan. At malamang pwedeng hindi lang isa, pwedeng dalawa, tatlo, depende kung ilang obligation ang mapapaloob sa isang kontrata. But, in an obligation, pwedeng mag-exist si obligation without a contract. Example, kasi may mga obligation tayo which is nanggaling sa batas mismo, di ba? Yung ibang nasa ibang sources ng obligation. It could be, right, kung naaalala nyo, it could be by law. Yun nga, yung second dun is yung contracts. Third is yung mga quasi-contracts, quasi-delicts, di ba? So, meaning, there can really be an obligation without a contract. But, there can be no contract na walang obligation. Kasi pag nag-enter ka nga ng contract, may lamang after nyan, magkakaroon ng obligation. Depende kung ano yung napag-usapan dun sa kontrata. Okay? Now, let's distinguish contract from an agreement naman. Contracts are actually an agreement, pero contract is enforceable through a legal proceedings. Kasi meron din namang mga agreement which cannot be enforced by action in courts. Example, if ever nagkaroon kayo ng agreement with your friends to meet up and have fun, manood ng sine, or what, kahit anong agreement, that is still an agreement. But that is not a contract as defined by Article 1305. Okay? An agreement is broader than a contract. So, all contracts are agreements, but not all agreements are contract. Okay? So, let's discuss naman itong stages in the life of a contract. Sabi, first stage daw ng life of a contract is yung preparation or conception. Ito yung preparatory step pa lang ang nangyayari, which is eventually, which will lead us to the perfection of the contract. Kumbaga, dito is yung bargaining point pa lang. Okay? May nag-offer pero hindi pa nagkakasundo. Wala pang meeting of minds as to the subject matter and the cost or considerations. After ng bargaining point, then nagkasundo na rin sa wakas. So, nagkaroon ng perfection ng contract. Ito yung second stage ng life ng contract. Dito na yung mayroon ng meeting of minds regarding the subject matter and the cost of the contract. Ito yung from the moment na yung parties come to an agreement or come to agree on the terms of their contract. Okay? Now, yung third stage ng life ni contracts is yung consummation. Okay? Or consummation. Ito na yung point kung saan tapos na yung birth ni contracts, di ba? Yung first stage is preparation or conception. Second, perfection, perfect na. So, third is consummation. Ito na nga yung time kung saan yung parties have to perform their respective obligations, which is nandoon sa kontrata nila. Okay? And so, after that, the contract is put to an end. Okay? Halimbawa, by December 1, okay, si Pogi nag-offer siya kay Ganda, binibenta niya yung kanyang sasakyan kay Ganda for 1 million pesos. Tapos, si Ganda ay nag-iisip-isip na. So, the following day, noong December 2, si Ganda ay nag-counter offer. Sabi niya, bibilhin niya lang yung sasakyan ni Pogi for 800,000 pesos lang. Okay? Bibilhin niya daw yung sasakyan ni Pogi if ibibigay siya ni Pogi at a price of 800,000 pesos. Suppose pumayag din kaagad si Pogi. Okay? Malaki yung kanyang pangangailangan. Kailangan niya ng pera. So, okay, Ganda. ibebenta ko sa'yo ang aking sasakyan ng 800,000 pesos. And pagka kinabukasan, so by December 3, 2020, eto na, dineliver na ni Pogi ang kanyang sasakyan to Ganda, and at the same time, si Ganda ay nagbayad ng 800,000 pesos to Pogi. Okay? So in this example, December 1, yun yung preparation or conception pa lang na stage ng life of a contract. Dito nangyari yung bargaining point. Dito yung negotiation process pa lang. Okay? Noong December 2, nagkaroon na ng perfection ng contract. Dito nagkaroon ng meeting of minds between Pogi and Ganda. Nag-offer si Ganda, di ba? Sa kanya yung nanggaling yung offer na bibilhin niya lang yung sasakyan if ibibenta ng 800,000 pesos. Pumayag si Pogi. So dito nagkaroon ng meeting of minds as to the subject matter and the cost of the contract. And sa December 3, eto na yung consummation or death or termination ng contract. That is when Pogi delivered the car and Ganda paid for the price or the 800,000 pesos. Okay? Doon na rin nagkaroon ng end as to the contract. Okay? So that is the stages in the life of a contract. Now, let's discuss yung kinds or classifications naman ng contract. First, a contract is classified according to perfection or formation. Sabi, pwede siyang consensual. Ito is pag yung perfected by mere consent. Example nga is yung sale. Benenta mo yung sasakyan mo, pumayag, so by consent. Okay? Tapos, ang second naman is yung real contracts. Ito naman is perfected by delivery. Yung example dito is yung contract ng deposit, pledge, or yung comodatum. Kailangan i-deliver yung object para ma-perfect yung contract. And the third is yung formal or solemn contract. Ito naman yung nangangailangan ng special formalities para yung contract ay ma-perfect. Example dito is yung donation. Kasi ni-require talaga siya na dapat pa nga is it must be in a public instrument para maging valid. Okay? Now, another classification ng contract is according to cost or equivalent of value of prestations. Pwede siyang onerous, pwede siyang gratuitous, and pwede siyang remunerative. When you say onerous, then dapat meron siyang equivalent valuable consideration. Okay? Dapat meron siyang interchange. Onerous. Tapos gratuitous pag free. Yung isang party ay walang matatanggap na he will not receive any equivalent prestations kasi nga for free, gratuitous. Tapos yung third is remunerative. Ito naman is pag yung prestation is given for a benefit or service that has been rendered previously. So, remunerative. Tapos na yung service na rendered na previously. Another classification ng contract is according to importance or dependence of one upon another. Pwede siyang principal. Okay? Pag stand-alone yung contract mismo, sales, lease, okay, yun mismo yung principal contract. And second, pwede siyang accessory. An example dito is yung mortgage. Kailangan merong principal obligation which is loan, tapos i-attach doon si mortgage. Si mortgage is an accessory contract. Okay? And pwede din pala siyang preparatory lang muna. Eto naman, pag yung parties ay hindi pa nila kino-consider yung contract as an end by itself, pero siya ay means lang for a future transactions or contracts pa na gagawin like yung agency or yung partnership. Now, pwede rin siyang ma-classify according to the parties obligated. Pwede siyang unilateral at pwede rin siyang bilateral. Ang ibig sabihin ng unilateral contract is that there is only one of the parties ang may obligation. Okay? Yung example dito is yung comodatum. Yung like example, naghihiram ka ng bisikleta. So, you have an obligation to return that bike afterwards. Now, please take note that although unilateral yung term sa kanya, it does not mean na walang consent. Kumbaga, isa lang yung mag-give ng consent. When you say unilateral contracts, yun nga, one parties has an obligation lang. Pero yung giving of consent, it must still be bilateral. Dapat mutual pa rin yun, okay? Do not be confused with the term. Now, another classification according to the parties obligated is yung bilateral contract. Yung both parties are required to render prestations. Okay? Yung dalawang parties or kung ilang parties man. Okay? So, example is yung sa sale. Yung isang party, yung seller has an obligation to deliver, tapos si buyer has an obligation to pay. So, both has an obligation. Okay? Anyway, yung third classification is according to their name or designation. Yung contract could be nominate. Ito yung kung merong particular name or designation ay binigay yung batas. Like example is yung contract ng partnership, contract ng sales, contract ng agency or deposit. Yun yung na-identify ni batas at na binigyan niya ng pangalan, okay? So, merong mga rules or specific rules na nag-govern sa kanila. Now, pwede rin naman si contract na innominate. Meaning, eto rin naman yung mga contract kung saan hindi pa nabigyan or walang special name. We also have classifications according to the subject matter. Pwede kasi yung contracts, it involves things like sale, di ba? Tapos, pwede ring involving rights or credits. Ito yung example dito is yung usufruct or yung assignment of credits. Tapos, pwede rin yung subject matter is of the contracts involves services. Ito naman yung agency or yung contract ng common carriage, ganon. Ganun lang siya kadali. Anyway, another classification is according to the number of persons who participated in the drafting of the contract. Ito talaga, gusto ko siyang i-add sa discussion kasi I want to discuss on the contract of adhesion. So, yung first is yung ordinary contract. Ito yung ordinary contract nga lang kung like yung sale, both parties involved or participated in the drafting of the contract. Lahat kayo may say. Tapos, meron tayong contract of adhesion. Etong contract of adhesion is prepared only by one person or by one party. Ito yung usually the only participation ng other party is to sign his name, his signature, kung tatanggapin niya or kung hindi. Pwede niyang i-refuse. So, the best example for this is yung contract na kung napapansin niyo, yung sa mga real estate company, di ba? Na-draft na nila ng corporation, tapos either mag-signify ka ng consent or hindi kung ayaw mo. Another is yung sa contract of insurance, di ba? Yung contract dyan, drafted na nila. So, yes or no ka na lang. Okay? Pero at least you have still a say kasi pwede ka namang, you have an option to refuse or to accept. Kumbaga, yung mga take it or leave it contract, yan yung characteristics ng contract of adhesion. Okay? Accept. Ganon. So, that's it. I think, yung ibang classification, if meron man tayong hindi na-discussed, pwede nyo nang basahin ng kayo na lang. But for me, those are, yung di-discuss natin, yun yung mga classification that, personally, in my opinion, yun nga lang, is yung mga important na at least ma-define or ma-discuss natin. Okay? So, let's proceed dito kasi mas mahalaga tong mga topic na to, yung mga different principles, yung mga basic principles ng contracts. So, first, we have autonomy of Contracts under Article 1306. Recontracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. So, this provision talks about the freedom to stipulate. Maraming itong tawag, iba-iba. Yung iba naman sa ibang libro, autonomy of will, principle of freedom, principle of autonomy of contracts. Pero sa discussion natin ngayon, we will refer this as autonomy of contracts. Okay? So, the right to enter into contracts actually is one of the liberties guaranteed by the Constitution. Okay? So, general rule, yung parties are actually free to stipulate into anything. Sabi pa nga they can establish such stipulations, clauses, terms, and conditions as they may deem convenient. Okay? Free tayong mag-stipulate ng kahit na anong gusto nating maging kasunduan. However, naglagay din siya ng limitations. And that is, provided na yung contracts ay legal. Sabi nga ni Article 1306, provided that they are not contrary to, unang-una, law, tapos morals, then good customs, public order, and public policy. So, eto yung mga limitations as stipulations. Pag contrary dun sa kanila, hindi na rin naman pwede. Okay? So, example is yung contract na vote buying, di ba? Binibenta yung boto. So, that is contrary to law and of course, public policy. Tapos, yung contract para ipasa mo yung estudyante mo, kailangan ng yung mga immoral conducts. So, that is contrary to morals. So, yun yung mga limitations na hindi pwede, hindi valid. Okay? Yun yung mga limitations sa principle ng freedom or autonomy of contracts. Okay? 1307. So, as discussed kanina, meron tayong contracts na may name or specific name or designation in law. Like yung sale, pledge, loan, ano pa ba yung sinabi ko kanina. And yung mga yan, like yung law ng sales, yun yung mag-govern sa contract of sales. Yung law on pledge, siya yung mag-govern sa contract of pledge. Same with loan, deposit, mortgage, yung mga ganon. But then, meron talagang contracts na innominate. Kumbaga, hindi pa napapangalanan at wala pang mga specific designation sa batas. Or eto yung mga innominate contracts. Okay? Mga contracts na walang specific name or designation sa batas. So, si Article 1307 provides for the answer kung ano ba ang mag-govern sa kanila. Diba? Kasi lahat, supposedly, dapat lahat may mag-govern. Eto, wala pa tong mga specific designation sa batas. So, ano ang mag-govern sa mga innominate contracts? And Article 1307 provides an answer for that question. Sabi, ang mag-govern daw sa mga innominate contracts ay number 1, yung stipulations ng parties mismo, okay? Yun dun mismo, or either sinabi nila na this agreement will be governed by ganito, the law on sales or something, or nag-provide mismo sila kung ano yung nandun, yun yung matutupad, yun yung law, di ba nga? Contracts are the law between the parties. Then, number 2, yung mag-govern din sa kanila is yung provisions, sabi daw ng Titles 1 and 2 of this book. Actually, this refers to the law on obligations and contracts. Okay? Ito yung pinag-aaralan natin. So, sa mga innominate contracts, mag-govern si obligation and contracts na ito. And then, number 3, yung rules governing the most analogous nominate contracts. So, kung ano daw yung batas, if ever, sa most analogous nominate contract. Ano ba yung other term for analogous? Yung law ng most analogous, most similar, most identical, or kung ano yung closest or congruent o yung pinakamalapit na klase ng kontrata, yun yung law. Halimbawa, yung contract na in-enter nyo ay similar to that of sales, then the law of sales will also apply or will govern that contract. Okay? And last is yung customs of the place. Usually naman, yung mga unique contracts, yun yung usually yung mga contracts which are specific to that place. Kumbaga, especially dito sa Pilipinas. So, yun yung ibig sabihin ni Article 1307. Now, actually, there are 4 kinds of innominate contracts. Okay? Number 1, sabi, doot des. Meaning, I give that you may give. Second, doot fascias. I give that you may do. And third, fasciot des. I do that you may give. And fourth is yung factoot fascias or I do that you may do. Okay? So, meron naman talagang innominate contracts kasi nga hindi rin naman posible na ma-anticipate lahat ng government at magawa nila ng specific law that will govern as to that particular contract. So, kaya eto as a general rule, eto daw in-address siya ni Article 1307. Article 1308. The contracts must bind both contracting parties. Its validity or compliance cannot be left to the will of one of them. So we are now with another principle in contracts, okay? Another characteristics ng contracts, which is commonly referred as the principle of mutuality of contract. Actually, simply put, eto sabi is both parties are bound. Meaning the principle is based on the equality of the parties, okay? Contract should not just be left or should not just depends upon the sole will ng isang parties lang, okay? Yung both parties are of the same footing, yung dalawa or kung ilan man sila na nasa kontrata. Okay? Hindi pwedeng isa lang yung magde-decide. After all nga, that's your agreement. Kumbaga, lahat ng parties are parties to that contract. Lahat might say. Hindi pwedeng pag ayaw na ng isa or kung kailan, kumbaga, according to his wills and ano lang talaga, biases. Remember, a contract is an agreement which will give rise to an obligations. So, a contract can be renewed, revived, extended, modified, renounced, terminated, kahit ano pang gusto nyong gawin dyan, by mutual consent ng parties. Okay? Mutuality of contract. Mutual consent. Lahat may say. Hindi pwedeng isa nga lang. Its validity or compliance cannot be left to the will of only one of them. Okay? Or of few of them kung napakarami nila. Hindi pwedeng ganun. Example, if sa loan contract, hindi pwedeng yung si creditor has a unilateral right to adjust the interest. So, paano yun? Siya yung mag-decide kung magkano yung interest, nasa sa kanyang sole discretion daw. Hindi pwede yung ganun. Malamang itataas at itataas na yun. Kailangan mag-agree talaga yung both parties na eto, 10%, 5%, o kahit pa mataas, basta nag-agree lahat yung parties. Okay? Ito, another example, ganito. If si Pogi, he agreed to sell his car to Ganda for, say, 1 million pesos. Ganyan. So, the contract is binding upon both contracting parties, upon Pogi and Ganda, di ba? Kung nag-agree silang dalawa, ibebenta at bibilihin yung car ni Pogi worth 1 million pesos. Now, if may stipulations doon na si Pogi alone, siya ang magde-determine ng price ng car, which will actually bind Ganda rin, Pero siya nga lang yung magdi-decide at walang choice si ganda. Hindi niya pwedeng tanggihan dahil ang option ay nasa kay Pogi lang. So that violates the principle of mutuality of contracts. Kasi sa, yun nga, mutuality of contracts, kung iisipin mo kasi, the contract is a meeting of minds, di ba? Meeting of minds between the parties. So, there must be mutual consent. Hindi nga pwede yung isa lang. So, dapat yung price, kahit pa si Pogi ang mag-determine, dapat i-accept ni ganda according din sa price na okay sa kanya. Okay? Then that's the time that the sale is perfected. But then, note din pala, the mere fact that a party to a contract has made a bad bargain, okay? Bad bargain in itself is not a ground for setting aside the agreement. Hindi porket yung isang contract is unfair pala yung pinasok mong kontrata later on ma-find out ko na unfair, parang lugi ka talaga. So, hindi pwedeng baliwalain mo na lang din yun. If in the first place, pumayag ka, nag-consent ka, nagkaroon ng perfection of contract. Okay? So, let's proceed to Article 1309. The determination of the performance may be left to a third person whose decision shall not be binding until it has been made known to both contracting parties. So, eto naman yung exception dun sa diniscuss natin kanina. Sabi, di ba, hindi pwede or yung compliance ng contract should not be left or cannot be left to the will of one of the contracting parties only. Hindi pwedeng sa kanya lang siya yung mag-decide. Okay? However, under dito kay Article 1309, ang determination of its performance may be left to a third person. Okay? So, example. Si Pogi, binenta niya yung kanyang sasakyan, lupa kay ganda. This time, nag-agree silang dalawa na yung magdi-determine ng price ng lupa would be Beauty. Kasi si Beauty pala is a real estate appraiser. So, siya ngayon ang magdi-determine ng reasonable price of the land. Okay? So, that is an example of Article 1309. Pwede yun. Pwedeng kay third person or si third person ang mag-determine. Pero, magiging binding lang yung decision or yung determination ni third person after niyang ipaalam sa parties. Okay? Yung decision or yung determination ng third person will bind the parties only if it was made known to both contracting parties, di ba? Pag binasa mo yung 1309, whose decision shall not be binding until it has been made known to both contracting parties. So, yun yung ibig sabihin nun. Now, this rule is actually not absolute rin naman. May exception din siya. And ang exception ay actually nasa kay Article 1310. So, proceed tayo kay Article 1310 na muna. So, the determination shall not be obligatory if it is evidently inequitable. In such case, the courts shall decide what is equitable under the circumstances. So, yung decision ni third person ay hindi rin binding if yung determination niya is evidently inequitable, okay? It is unjust. Kasi baka nga naman yung third person ay nag-act in bad faith, okay? So, kung kaya yung determination niya is napakahalata, it is actually inequitable talaga, unfair to the highest level, char. Pero yun nga, evidently naman, evidently inequitable. So, if ganon, yung court na yung magdi-decide. Sabi ni Article 1310, okay? In such case, the court shall decide what is equitable under the circumstances. So, si court will decide what is equitable. That's Article 1310. Ganyan lang siya kasimple. So let's proceed to Article 1311. Contracts takes effect only between the parties, their assigns and heirs, except in case where the rights and obligations arising from the contracts are not transmissible by their nature, or by stipulation, or by provision of law. The heir is not liable beyond the value of the property he received from the decedent. If a contract should contain some stipulation in favor of a third person, he may demand its fulfillment provided he communicated his acceptance to the obligor before its revocation. A mere incidental benefit or interest of a person is not sufficient. The contracting parties must have clearly and deliberately conferred a favor upon a third person. So, let's take another principle or characteristics ng contracts. Tapos na natin yung mutuality of contracts. Tapos na rin tayo sa, ano ba yung una? Freedom to stipulate. So, eto naman, relativity of contracts. So, the principle of relativity, meaning yung contracts are generally effective only between the parties. Yan, yung parties mismo or yung assigns or heirs nila. Diba? Yun yung bungad talaga ng provisions ng Article 1311. So, general rule, contracts will take effect only between the parties, their assigns, and heirs. Yan yung principle of relativity. Meaning, if ever ganito, if si Pogi may utang siya kay Ganda na 1 million pesos, so silang dalawa yung parties. The contract will take effect between them. Okay? Pero, if later on, namatay si Ganda, so yung bayad ni Pogi ay ibibigay niya sa mga heirs ni Ganda. Okay? Nasusundan niyo? They are heirs or assigns, di ba? Now, same way naman if yung namatay ay si Pogi. So, if si Pogi ang namatay, then the heirs of Pogi will pay Ganda 1 million pesos. Kasi effective din sa kanila nga yung contract. Now, provided naman na mayroong natitirang property si Pogi na pwedeng ipambayad sa utang ni Ganda, yun yung ibabayad ng mga heirs ni Pogi to Ganda. Okay? Yung nasa last sentence ng first paragraph, Article 1311, pansinin nyo, sabi, the heirs is not liable beyond the value of the property he received from the decedent. Okay? So, yun nga yung ibig kong sabihin kanina, na provided na mayroong natitirang property si Pogi na worth 1 million pesos, so yun yung ibabayad ng kanyang heirs papunta sa kay Ganda kasi creditor si Ganda dito. If ever sobra-sobra naman, di bayaran muna nila si Ganda tapos tsaka nila hati-hatiin yung mana nila kay Pogi. Parang ganun kasi siya. Pero pag yung value ng property ay kulang to the amount, di ba? Kulang pa sa 1 million peso na utang ni Pogi kay Ganda, then hindi naman mag-shell out yung kanyang mga heirs. Kasi sabi nga ng last sentence, the heir is not liable beyond the value of the property they or he received from the decedent. Hindi na mamana yung utang. Pero yung property na namana mo ay pwede mo pang gamitin pambayad kasi yun yung first preference. Dapat ibayad mo na yun sa mga utang at yung natira nga, yun yung paghahati-hatian ng mga heirs. Anyway, malayo na yun sa Article 1311. So, balik tayo dito. Same scenario rin naman ang mangyayari if before namatay si Pogi or si Ganda, is inassign niya sa iba or to third person yung utang niya, yun yung ibig sabihin ng principle of relativity. First sentence ng paragraph ng Article 1311. Now, nag-provide din si Article 1311 ng exceptions. Diba? Sabi pa nga ito, except in case where The rights and obligations arising from the contracts are not transmissible by their nature or by stipulations or by provisions of law. Diba? Okay, ganito. Diba nga, contracts take effect between the parties, their assigns, and heirs. Kasama yung assigns tsaka yung heirs. Pero yung exception din daw dyan is kung yung rights and obligation which arise from that contract is actually not transmissible. So, paano mo lalalaman na hindi siya transmissible? Pwedeng by their nature, hindi talaga siya transmissible. Like, yung usapan ni Pogi and Ganda was to paint for Ganda. And later on, namatay si Pogi. By nature, hindi naman talaga transmissible yung obligation na yun. So, hindi pwedeng yung heirs na lang ni Pogi ang mag-paint for Ganda. Okay? Now, another exception daw is kung yung rights and obligations arising from that contract are not transmissible then by stipulations. Okay? If nasa usapan mismo nung dalawa, ni Pogi and ni Ganda na hindi yun transmissible kay sa kanilang mga heirs at sa kanilang assigns. Kumbaga, between sa kanilang dalawa lang talaga. Now, another exception na rin is na kung saan hindi nga rin siya or yung rights and obligations that arise from that contract actually not be transmissible nga din to the heirs or assigns is tag by provision of law, hindi siya transmissible. So, anong example dito? Partnership. Kasi sa partnership, the law on partnership, pag namatay yung isang partner, automatic, may extinguish yung partnership. Hindi pwedeng namatay yung partner kayo, tapos namatay yung isa mong partner. So, hindi siya namamana. Like, biglang yung partner mo na lang is yung anak niya. Okay? Hindi siya ganun. And so, that is an example for an obligation or rights that is not transmissible under the law. So, yan. Yun na yung first paragraph ng Article 1311, na-tackle na natin siya, na-discuss na natin. Now, let's proceed. Balikan natin ulit yung sinabi ko kanina. Article 1311 provides for a principle of relativity of contract. Ang ibig sabihin, sila lang ang may rights and obligations under that contract. Okay? Yan yung ibig sabihin ng principle of relativity. Yung parties lang. And pwede rin yung kanilang assigns or yung heirs nila provided na hindi, kumbaga, yung rights and obligation that arise from that contract are transmissible. Baka naman kasi hindi siya transmissible. Now, ito yung gusto kong i-point out dito sa sinasabi ko. Dahil nga relativity sa kanila lang yun, mag-take effect yung contract. Hindi kasama ang hindi parties to that contract. Yung mga hindi privy to that contract. Okay? Yung mga strangers, third person, wala silang sabi o wala silang say dyan sa contract na yan. So, strangers cannot demand for the enforcement of your contract. At mas lalong, hindi rin siya pwedeng mag-demand for its annulment. So, eto, another example. Binenta na ni Ganda kanyang sasakyan, tapos on installment basis. Okay? Meron silang agreement na hindi pwedeng ibenta ni Pogi yung sasakyan sa iba hanggat hindi pa nababayaran ang buong amount kay Ganda. Okay? So, later on, itong si Pogi, kahit hindi pa man niya tapos bayaran si Ganda, diba? Contrary dun sa usapan nila, binenta niya na ang sasakyan kay Beauty. Question, can Ganda cancel the sale? Pwede niya bang i-cancel yung contract ni Pogi at ni Beauty? Kasi yung sale ay nasa sa kanila. The answer is no. Why? Because Beauty was not a party to the agreement between Pogi and Ganda. In the same way, hindi rin party si Ganda dun sa agreement between Pogi and Beauty. So, ano ang remedy ni Ganda? The remedy of Ganda is actually to claim for damages from Pogi dahil for the breach of contract. Kasi may usapan sila hindi pwedeng ibenta sa iba, pero binenta niya kay Beauty kahit hindi pa naman siya bayad or fully paid. So, wala siyang right to cancel that contract between Pogi and Beauty. Okay? Under the principle of relativity. So, another example, para mas maintindihan niyo itong principle of relativity. Eto, sa lease contract naman tayo. Supposedly, si Pogi, he leased his property to Ganda. Now, etong si Ganda, contrary or in violation doon sa lease contract nila ni Pogi, nag-sublist siya. Part of the premise ay part dun sa inupahan niya, pinarentahan niya rin kay Beauty. Okay? Kahit na may condition doon sa contract of lease between Pogi and Ganda na bawal mag-sublist. So, since yun na nga, nag-sublist pa rin si Ganda in violation doon sa contract nila ni Pogi, so Pogi now goes to court to rescind the contract. Gusto niyang i-rescind yung contract nila ni Ganda. So, question, can Beauty object the rescission on the ground that if the contract is rescinded, yung sublist niya with Ganda would be affected? Okay? So, under the principle of relativity, hindi party si Beauty sa contract ni Pogi and ni Ganda. So, the answer is no. Because Pogi is not bound by the sublist contract between Ganda and Beauty. Diba? Hindi naman siya kasama dun sa list contract between Ganda and Beauty. And si Beauty ay hindi rin party sa contract between Pogi and Ganda. Right? So, walang standing si Beauty to question or to object the rescission of contract. Kasi, in the part of Ganda naman, nag-violate din talaga siya sa condition ng kontrata nila with Pogi. So, that is relativity of contract. Klaro na ba sa inyo? Anyway, pag hindi klaro pa, comment down. Parang ewan ko, sana hopefully naintindihan nyo. Kasi baka lang medyo complicated at baka nga naman ako lang yung nakakaintindi sa explanation ko. Sana malinaw kasi yun ay nag-set pa lang tayo ng general rule. So, we will still be discussing some of the exceptions to this provision, to the principle of relativity. Ito ay ang nasa second paragraph mismo. Basahin natin again, okay? If a contract should contain some stipulation in favor of a third person, he may demand its fulfillment provided he communicated his acceptance to the obligor before its revocation. So this is called stipulation for Autrui. So this is a stipulation in favor of a third person made by the contracting parties with a clear and deliberate intention of conferring a favor upon that third person. Okay? And to be valid, eto ha, so discuss na rin natin si stipulation for Autrui. So, in order for a stipulation for Autrui to be valid, dapat it must conform to these requisites. First, there must be a stipulation if in favor of a third person. Obviously, yun talaga yung pinakauna. Yung merong stipulation in favor of a third person. Second, dapat yung contracting parties must have clearly and deliberately conferred a favor to the third person. Hindi dapat incidental lang. Okay? And the third requisites, the stipulation should be a part. Okay? Hindi, part lang siya. Part lang nung contract mismo. Hindi siya yung whole of the contract or the contract itself. Okay? Na hindi siya mismo na siya, yung laman ng contract is actually giving that favor to that specific third person lang talaga. So, kumbaga, part lang siya. May stipulation lang which grants favor to third person. Pero, as a whole, syempre, may iba talagang purpose yung contract. And fourth, the third person must have communicated his acceptance to the obligor before its revocation by the obligee or the original parties. Okay? Dapat i-communicate niya yung acceptance. Okay? Then, fifth, neither of the contracting parties bears the legal representation or authorization of the third party, for otherwise the roles on agency will apply. Anyway, to better understand this stipulation for Autrui, let's take an example. So, halimbawa, si Pogi may utang siya kay Ganda na 10,000 pesos, tapos may interest na 12%, payable on December 25, 2020. Tapos, doon sa contract, yung 12% interest daw ay ibibigay kay Beauty, a third person. Hindi siya parties ng contract ng dalawa. Pero, sa kanya ibibigay yung 12% interest. So, take note nga that the parties in the contract is Pogi and Ganda. But, meron siyang stipulation in favor of Beauty. Di ba nga? So, dito sa situation na to, dapat si Beauty, she must communicate his acceptance to Pogi and Ganda. Otherwise, hindi siya mai-entitled to the benefit of the contract. Okay? So, that is an example of a stipulation for Autrui. So, the moment Beauty communicated her acceptance, Beauty becomes a party to the contract. Okay? So, that is Article 1311. Pero, hindi pa dyan nagtatapos ang Principle of Relativity. The next provision, Article 1312, is actually another exception to the Principle of Relativity. Okay? Ito yung when third person is bound by contracts creating real rights. So, that is an exception. And another exception pa nga to the principle of relativity is found under Article 1313. Ito naman yung sa right of defrauded creditors. And yung last exception na i-discuss natin today is yung nasa kay Article 1314. Exception pa rin siya ng principle of relativity. And eto naman is yung sa contract or when contract is violated through inducement by a third person. So yan yung mga cases kung saan magkakaroon ng exception to the principle of relativity. Now, let's continue our discussion with Article 1312, okay? So, Article 1312, in contracts creating real rights, third persons who come into possession of the object of the contract are bound thereby, subject to the provisions of the mortgage law and the land registration laws. So, yun na nga, this article or this provision is an exception to the general rule that a contract binds only the parties. Kasi sabi dito, yung third person is bound by contracts creating real rights. Okay? Mas maganda siya pag through example. So, eto, proceed na lang tayo sa example. Ganito. Suppose, itong si Pogi, minortgage niya yung kanyang lupa kay Ganda. Okay? So, merong mortgage as to that parcel of land ni Pogi in favor of Ganda as a security for his debt. Okay? Now, yung mortgage na yun is actually naka-registered in the Registry of Property. So, since owner pa rin naman si Pogi ng kanyang lupa, after niyang i-mortgage yun kay Ganda, since gipit pa rin siya, kulang pa rin yung pera niya, binenta niya ngayon itong lupa kay Beauty. So, in this case, binili nga ni Beauty at Dun sa pagbili niya, di ba? Alam natin na meron siyang encumbrance. Dahil yung lupang yun ay merong mortgage na in favor kay Ganda. So, in other words, kahit pa si Ganda ay hindi party ng contract of sale between Pogi and Beauty, dahil sa contract of mortgage, dahil merong pre-existing contract of mortgage which is actually a real rights dahil naka-register siya sa Registry of Property, then si Beauty will be bound by the contract between Pogi and Ganda. Irerespeto niya yun. Kahit pa nga sana hindi naman party si Ganda, irerespeto niya yung right ni Ganda. Sa contract ni Pogi at ni Ganda, third person si Beauty. Sa contract ni Pogi at ni Beauty, third person si Ganda. Pero kailangang irespeto ni Beauty yung right ni Ganda over that property dun sa mortgage. Kailangan niyang irespeto yung mortgage dahil yun yung sabi ni Article 1312. Right? Let's proceed to Article 1313. Ito naman is another exception pa rin kay contract of relativity. So, medyo mahaba tong principle of relativity. Okay? So, Article 1313. Creditors are protected in cases of contracts intended to defraud them. Yun lang sinabi niya. So, it refers to the right of creditor to impugn contracts intended to defraud them. It is, again, another instance when an outsider, a third person, or a stranger can interfere with another contract. Okay? The concept is actually not new kasi parang na-discuss na rin natin siya in passing sa mga previous lectures natin. Pero eto, halimbawa, if si Pogi may utang siya kay Ganda na 1 million pesos, tapos itong si Pogi, may property siya, may lupa siyang nakapangalan sa kanya. At dahil ayaw niyang ma-attach ang property na yon bago pa man ang due date ng utang niya kay Ganda, kasi wala siyang pambayad, at alam niya na ang mangyayari ay i-attach ang lupa na yon as pambayad doon sa utang niya kay Ganda. So, ang ginawa niya, to defraud Ganda, dinonate niya yung lupa kay Beauty. Para wala nang mahagilap, di ba, si Ganda. Wala siyang makuhang property pang bayad sa utang sa kanya. So, in this case, dahil si Ganda is actually a defrauded creditor, siya ay may right to impugn the contracts between Pogi and Beauty, although she is not a party to that contract. She is a stranger, right? She is given by law the right to ask for the rescission or the cancellation of that donation in order that or she may be paid. Okay, so that's Article 1313. Let's proceed to Article 1314. This is another exception to the principle of relativity. Article 1314. Any third person who induces another to violate his contract shall be liable for damages to the other contracting party. So again, this provision provides for another exception to the principle of relativity. Pag binasa mo nga yung provision, makikita mo na kaagad, diba? Na yung contracting party ito si contracting party, yung injured party, ay may right to claim for damages against that person who induces, diba? Yung kanyang kontrata to violate his contract. So exception nga rin siya sa principle of relativity. Yung stranger to the contract, kahit a stranger siya sa contract, pwede siyang makasuhan, okay? Action can be filed against him in view of his unwarranted interferences. So whoever is injured may sue for damages. He can claim for damages, yung injured party. So the word induce in this provision refers to situations where a person causes another to choose one course of conduct by persuasion or intimidation. So eto, let's take an example. Supposedly, sabihin na natin si Ganda is a movie actress. Okay? Isa siyang sikat na artista who has a 1-year contract with 123 Studio. So, if etong si Beauty, a friend of Ganda, in-induce si Ganda without any justifiable cause to break the contract, then etong si 123 Studio can sue Beauty for damages. Okay? So, in this example, the liability of Beauty does not arise ex contracto for actually, wala namang kontrata between Beauty and that studio, that 123 Studio. Pero dahil sa Article 1314, pwedeng makapag-file ng case or makaka-claim ng damages si 123 Studio against Beauty. Dahil si Beauty, she actually induces Ganda to violate her contract with 123 Studio. Okay? Now, a third person is not liable where sufficient justification for interference or inducement can be shown. Dun kasi sa example natin, without justifiable cause. Parang in-induce lang talaga ni Beauty si Ganda to break her contract with the 123 Studio. Okay? So that's it. That's Article 1314, and that's all for the principle of relativity. So at last, makakapag-proceed na tayo with another principle, another provision. Article 1315. Contracts are perfected by mere consent, and from that moment, the parties are bound not only to the fulfillment of what has been expressly stipulated, but also to all the consequences which, according to their nature, may be in keeping with good faith, usage, and law. So, this refers to the another principle or characteristics of contracts, the consensuality of contracts. Okay? It simply means perfection ng contract by mere consent of the parties regarding the subject matter or the object of the contract and the cause of the contract. So, COC. Consent as to the object and to the cause of the contract. Now, signing is not generally a legal requirement in entering into a contract. Ang importante lang naman talaga is meeting of minds. Yun nga yung sabi ko rin kanina, it's not necessary naman for a contract to be in writing unless require siya ng batas to be in writing or to have some specific formalities like nga yung sa deed of donation. Kasi as a general rule, yung contracts are perfected by mere consent. By the time nagkaroon ng meeting of minds between the parties as to the subject matter and the cause of the contract. Okay? So, yun yung general rule. Now, meron siyang mga exceptions. First doon is in case of real contracts at saka yung sa formal contracts. When you say real contracts, ito yung kailangan ng delivery. At pag sinabi mo ng formal or ito yung solemn contracts, ito yung mga nagre-required na ng specific form or specific documents like kailangan naka-public document siya. Anyway, na-discuss na natin siya kanina and I don't want to sound so redundant na pabalik-balik. Kasi lalo na pag nakikita kong napakahaba na ng discussion, we need to end this na. So, we have to focus on kung ano ba yung importanteng topic na kailangan pa natin i-discuss. Okay? So, Eto na, ano naman yung consequence ng perfection ng contract? Sabi, according to Article 1315, merong dalawa. The parties will be bound first to the fulfillment of what has been expressly stipulated. Okay? They will now be bound to the fulfillment kung ano man yung napag-usapan nila. And second, kasama din syempre, hindi lang dun sa napag-usapan but as to the consequences rin. Okay? Na according to their nature may be in keeping with good faith, usage, and law. So, yun yung consequence ng perfection ng contracts. Now, let's discuss naman Article 1316. Ito yung first exception to the rule ng consensuality of contracts. Okay? Kung saan dapat general rule contracts is perfected by mere consent. Si Article 1316, hindi lang mere consent para maging perfect yung contracts. Sabi, real contracts such as deposit, pledge, and comodatum are not perfected until the delivery of the object of the obligation. So, dito nga, yung perfection ng contracts, actually, same pa rin naman consent, pero may nadagdag lang na requirement, and that is delivery. Okay? In real contracts, delivery is required for the perfection of the contract. Now, let's take an example. On June 1, Pogi borrowed money from Ganda worth 10,000 pesos with a promise that Pogi will give his diamond ring to Ganda as a security on June 15. Now, before June 15, even if binigay na ni Ganda kay Pogi ang 10,000 pesos, the contract of pledge is not yet perfected. Why? Because in the contract of pledge, the perfection is only upon the delivery of the object pledge. Hindi niya pa rin naman na i-deliver kay Ganda yung diamond ring. So, wala pang contract of pledge. Pero, meron na yung contract of loan kasi binigay na ni Ganda kay Pogi ang 10,000 pesos. Okay? That's it. That's Article 1316. Now, let's proceed to the last article na i-discuss natin with this topic. Excited na makayong matapos. Ang haba na. Anyway, Article 1317. No one may contract in the name of another without being authorized by the latter, or unless he has by law a right to represent him. A contract entered into in the name of another by one who has no authority or legal representation or has acted beyond his powers shall be unenforceable unless it is ratified expressly or impliedly by the person on whose behalf it has been executed before it is revoked by the other contracting parties. So, this provision talks about a form of unenforceable contracts. Kasi later on, pag nag-discuss na tayo dun sa mga defective contracts, we will be discussing yung iba pang mga instances kung saan merong unenforceable contract. Anyway, itong Article 1317 simply says na, kumbaga, ang ibig lang sabihin nito is that yung mga unauthorized contracts or yung contracts entered into without the authority of the principal, so yun ay mga unenforceable contracts daw. Okay? So, example, ganito. Halimbawa, si Ganda ay may sasakyan. And, yung sasakyan na yun ay binenta ni Pogi in the name of Ganda. Pero wala siyang authority from Ganda. Okay, binenta niya to kay Beauty. So, yung sale being unauthorized is unenforceable. Okay, hindi siya valid. Now, kung ano ba yung epekto ng unenforceable contracts, we will be discussing that when we reach our discussion dun sa defective contracts nga. Okay? Magkakaroon tayo ng video lectures with regard to unenforceable contracts. Separate dito. So, for now, let's just focus on the concept na yung mga contract entered into in the name of the owner or another person, tapos without that authority from that person is unenforceable. Yun lang yung ibig sabihin ni Article 1317. And so, nag-provide siya ng mga instances kung saan yung contract na in-enter into by a person in the name of another. Sabi, ay pwede mo naman maging valid if, ito yung mga requirements. Una sa lahat, if he is authorized either expressly or impliedly. Okay? Pwedeng written yung authority which is much better para at least may proof, di ba? Pero pwede rin namang impliedly through the conduct lang ng another person which is, we used to call that principal. Tapos yung nagbebenta is si agent. Pwede siyang with authority or without authority. So, pag without authority, yun ay unenforceable contracts. Pag may authority, inauthorized siya, so pwede. Okay? Then, another scenario, which is actually provided in Article 1317 is, pag daw, yung law mismo has given him the right to represent him. Like yung sa mga guardian ng mga minor, di ba? Although walang express authorization from the minor, pero by law, the guardian is authorized to represent that minor. Although, hindi sa lahat ng situation kasi meron talagang instances wherein nag-require din yung batas ng at least legal guardian talaga. Now, another scenario kung saan pwede pa rin mag-enter into a contract yung person in the name of another is pag daw yung contract is subsequently ratified. Okay? So, eto, nung nag-enter si isang tao in the name of that other person, wala siyang authority. Pero later on, subsequently, ni-ratify nung principal. Pwede siyang express or implied pa rin. Okay? Pag ni-ratify ni principal, example, dun pa rin sa example natin kanina. Although walang authority from Ganda na ibenta ni Pogi yung car niya, if later on naman, diba, kinolekta ni Ganda yung bayad from Beauty. So, that is an implied ratification dun sa pagbenta ni Pogi ng sasakyan kasi kinuha niya yung benefits, kinolekta niya yung bayad. So, ratification cleanses the contract from its defect. So, meron siyang retroactive effect from the moment the contract was entered into. Okay? Another requirement din, aside dun sa tatlo, aside from that requirement, ang isa pa, ang kailangan mo ding tandaan dito is that dapat din daw, dapat he must act within his power. Okay? If you are just authorized to lease, okay, paupahan mo lang daw yung lupa, huwag mong ibenta kasi yung authority mo is to list only. So, if binenta mo, so you acted beyond your power. So, hindi na rin, unenforceable na rin yan. Okay? That's it. That's Article 1317. Thank you for watching. See you on our next video. God bless.